Welcome back to the county seat. Thank you for rejoining us for our broadcast. We are talking about indigent defense, some of the challenges that are facing the state. A report issued by the Utah ACLU called Failing Gideon, which to me sounded like it was closer to Brown versus Board of Education, but it's really about Gideon versus Wainwright and the right to representation, even if you can't afford it. And joining us for the discussion, John Mejia, Legal Director of the ACLU of Utah, Emily Chang, who's an associate professor at the law school at the University of Utah. I truncated it this time. And David Brickey, who's the Summit County attorney. So when we're talking about the fiscal side of this argument and the fact that the counties are sometimes strapped and challenged to provide indigent defense, and it may not be very popular, during the break, a conversation came up about some of the hidden costs, and I would like to address that because it was enlightening to me. What do you see as some of the hidden costs that, if you don't address the problem, creep up?
Well, for one thing, you might put innocent people in jail, which is, not just a waste of resources, but it's a moral cost. Nobody wants to see an innocent person to go to jail, and without adequate funding, adequate time, adequate resources, you sort of start running into that risk. Also, even if the person, pleads guilty, we want to make sure that the person gets the right amount of time in jail or prison. Those are also costs that we all absorb. And, let's say that they, if you looked at it, if you had the time to look at it fairly, they should have been spending maybe 5 years, but they get a sentence of 15 because the defender didn't have time to look into that. Or maybe they got a sentence of 1 year, they should have been going for community service or probation. So, not having an adequately funded public defender in the first instance can lead to costs, like you said, that are hidden, that you don't see until they actually happen.
Emily, what about the pretrial side?
Yeah, I was going to say on the front end, even setting aside the type of sentence that a person gets, pretrial detention is expensive. It adds up. Most counties track how much it costs per day to house a person in county detention, in jail. And what happens if your lawyer doesn't have time to visit you, doesn't have time to make a motion to get you out on bond, is filing continuances because they're too busy or they can't make it over or they haven't had time to, investigate your case, that's dollars that the county is paying to house you in county detention that maybe it doesn't need to be paying. So in some sense, when counties try to save money on the front end with low bid contracts, for example, for public defenders, it's penny wise but pound foolish because you end up paying more on the back end.
David?
Well, I think the counties recognize the need to have prepared and adequately trained defense attorneys. Sending a young lawyer a year out of law school in on a case of significant magnitude I'd hate to deal with a young lawyer who's just out of law school on an aggravated assault, or let alone a speeding ticket. If you've got a minor, let's pick a juvenile who's driving dad's car, and the last segment that you did, I heard the defense attorney talking about, he's sitting in the car's stopped, and the passenger in it has nothing to do with drugs found in the car because they're someone else's. I don't want a young lawyer who doesn't recognize certain case law that would be an absolute valid defense that's not raised. I think as a county attorney, we have an obligation to go, geez, this is an inadequately trained lawyer, and then we'd have to review whether or not that person should be serving in that capacity. I think that front-end recognition is something that's also done when the hiring takes place. We don't want to see ill-prepared representation.
Well, it's inefficient for your office too,
absolutely.
Right?
If someone comes back at sentencing because defense counsel was not prepared at the initial sentencing, it's wasting the judge's time. We're potentially leaving the public wondering just how does this system work? And we've got to do it right the first time. And recognizing they have some valid concerns. I'm not denying that there is a process here that can be improved upon, but I think the counties have the best way of solving that by allowing us to do our jobs at a local level.
And going back to your example of a young person who's caught in a car with drugs, maybe that young person they had nothing to do with the drugs, it was the driver's drugs, and if you have a contract like many counties do, where you have the same defense attorney, you have one defense attorney, And it's up to the defense attorney to figure out whether there's a conflict of interest between the driver and the passenger. And you have a contract that doesn't provide for costs for what's called conflict counsel, which would be when you call in a separate attorney for the passenger. And the way that the counties, a lot of counties have set up their contracts, if you're going to call in conflict counsel, the defense attorney is going to have to pay for that out of his or her own contract.
Does your model contract get into that area?
Absolutely addresses that. That is something that came of light in the last couple of years. There's not a county attorney that I've crossed paths with in the last 2 years that have said that's appropriate. If the contract identifies, and there's not a justice court judge or district court judge that wouldn't look at that situation and say, counsel, how can you represent two individuals? You're going to need to find someone else to represent this person, and the county's going to be on the hook for it. The county should be. We're prosecuting, we're a big entity, we have a lot of access to investigators and resources. The least we can do is make sure that that defendant has an attorney to represent them. And we recognize that, and our model contract will take care of that. So I think it's almost as if, with all due respect to the ACLU, looking for a problem when there's none there.
Well, I will say, I think part of the issue with having things on a purely county-by-county level is you need some cross-county communication. And sometimes the counties do that on their own, but let's say you have, in many counties, public defenders will work in multiple counties. So you can have one guy who represents clients in 3 or 4 different counties, right? And the problem is you can have County A is screening his conflicts for that county, and County B is screening his conflicts for that county, but you might have conflicts across counties, and so there needs to be some sort of mechanism by which it's not just purely up to the individual county, right? Because even if all of the counties are operating in good faith, they use the model contract, they set up a conflict screening system within their own personal county, given the way things work in Utah, where a lot of times lawyers work across counties, you need to have some mechanism where there's a cross-county sharing as well, right?
And I don't think that that's inaccurate. I welcome the opportunity to figure out how to make that implementation of that. It ignores the fact, though, that those same attorneys who are ignoring those conflicts have an ethical violation that they're aware of, and they're not addressing it. If I learn about one of our public defenders who's in another county who cross-examines perhaps a witness in that county that he represented in Summit County, I'll report him to the bar.
But
that would never be appropriate.
I think that, sometimes you're going to have the lawyer who knows of the conflict and disregards it. But I think you have plenty of attorneys who maybe it was someone you worked with 5 years ago, or it was a witness in your case and not the defendant, and you don't remember, right? I think given people's caseloads, everyone's busy. You have private cases, you have public cases. Some folks are doing city cases and county cases. It's not enough to rely on the individual lawyer or the individual county. What I'm saying is you need something more. And that something more, it might be state involvement, it might be a regional office, it might be a cooperation of counties.
But how would that really, I don't see that would necessarily make a difference, because it's a cognition issue at one level versus another.
No, what you need is a database. What you need is what most offices have to check conflicts is you enter all of the names into some sort of central database, and then every time you get a new client, you type that in, and it pulls up, oh, this is a person where I previously represented their spouse in a divorce case, or...
So basically you're looking for kind of a Lexus solution, not talking about the car, mind you. But a database solution rather than actually a staffed office with directives is just a resource that can be managed to help cover those sorts of things. It seems to me that might be the solution.
I think this is one of the many examples where for relatively small investment, either a group of counties, a region of counties, or the state could invest some very small amount of money to set up, let's have a database of all of the names. Right? And so that if 4 counties are sharing 3 lawyers, those counties know if a conflict is going to come up. Or those 4 lawyers can share their briefs with one another, right? So there's no need to reinvent the wheel. And it encourages efficient use of resources. So that if you have, a DUI case or a drug possession case, and it's an open and shut issue, you can just type it in, and then you see, oh, wait, Joe in the county next door already filed a motion on this. right?
But I do know, addressing, there's two issues there I'd like to address. One is the idea of a matrix that allows for one public defender in one county to identify potential conflicts from previous representation. I think it's a great idea. Let's explore how to make that happen. The second is that you already have the Utah Defense Bar has a brief bank. I can't even access it. It's code protected, and I would imagine the public defenders have access to it, but I think we certainly should ask the Defense Bar, are they making it available to also public defenders? Because if they were as busy as anybody else in the practice of law, reinventing the wheel is just an inefficient use of your time. And if they can get access to that brief bank, I'll assist them in any way they can, but they won't give me access any time in the future. I recognize
This
that.
is David's ploy.
Let's continue this conversation after the break. We've got to break away. When we come back, I'd like to spend a little time on the constitutional side of this entire debate and why it's so important. We'll be right back.